Outlines. 1. Medical records. Medical/health records. Medical record, also referred to as record. A single record of all data on an individual's health status from birth to death. Birth records. Immunization records. Records of all illnesses and treatments given in any healthcare facility. Used in the management and planning of healthcare facilities and services, for medical research, and the production of healthcare statistics. Doctors, nurses, and other healthcare professionals write up medical/health records so that previous medical information is available when the patient returns to the healthcare facility. 4 major sections. Administrative. Includes demographic and socioeconomic data such as the name of the patient, identification, sex, date of birth, place of birth, patient's permanent address, and medical record number. Legal data. Including assigned consent for treatment by appointed doctors and authorization for the release of information. Financial data. Relating to the payment of fees for medical services and hospital accommodation. Clinical data. Whether admitted to the hospital or treated as an outpatient or an emergency patient. Main uses. To document the course of the patient's illness and treatment. To communicate between attending doctors and other healthcare professionals providing care to the patient. For the continuing care of the patient. For research of specific diseases and treatment. The collection of health statistics. Where does the medical record begin? The medical record begins with the patient's first admission as an inpatient or attendance as an outpatient, if a combined medical record, to the healthcare facility. This begins with the collection of identification information, which is recorded on the front sheet or identification and summary sheet. Patient identification. Some useful unique patient characteristics are a national identification number or a social security number, date of birth, health insurance number, mother's maiden name, mother's first name, father's first name. In the case of a newborn infant, a biological characteristic, e.g. fingerprint or footprint. The following are not considered unique characteristics. Where a person lives is not a unique patient characteristic because it can change. A person's age is not a unique patient characteristic because it does change. Although it should not change, it is important that a patient's birthplace is not used, as it is often identified by most people as being the place where they come from as opposed to the place where they were actually born. Asterisk. Effective patient identification is the beginning of an efficient medical record system. Medical record numbering. The collection of patient identification data and the assignment of a medical record number or verification of an existing medical record number should be the first step in every admission procedure. One patient, one medical record number equals one medical record. Medical records forms and order. The medical record is made up of a number of forms, which are all used for a specific purpose. The basic set of forms in the inpatient medical record includes front sheet or identification and summary sheet, which covers identification, final diagnoses, disease and operation codes, and the attending doctor's signature. Consent for treatment is often on the back of the front sheet and must be signed by the patient at the time of admission. There are 2 parts to this form. The first half of the form is a general consent for treatment and the bottom half is consent to release information to authorized persons. Correspondence and legal documents received about the patient, example referral letter, requests for information, etc. Discharge summary. A discharge summary is a summary of the patient's stay in hospital written by the attending doctor. The minimum detail provided in a discharge summary is patient identification, reason for admission, examinations and findings, treatment while in hospital, proposed follow-up, admission notes, including the patient's family medical history, the patient's past medical history, presenting symptoms, results of a physical examination, provisional diagnosis, the reason the patient came or was brought to hospital, proposed tests and care. Clinical progress notes recording the patient's daily treatment and reaction to that treatment written by the attending doctor and other healthcare professionals. Nurses' progress notes recording daily nursing care including temperature, pulse, and respiration charts, blood pressure charts, etc. Operation report if an operation or operations are performed. Other healthcare professional notes, example physiotherapy, pharmacist, etc. Pathology reports including hematology, histology, microbiology, etc. Other reports, X-ray, etc. Orders for treatment and medication forms listing daily medications ordered and given with signatures of the doctor prescribing the treatment and the nurse administering it. Special nursing forms for observation of head injuries, etc. Responsibility for medical records. The hospital administration is legally responsible for the quality of care given to patients. Responsibility for direct patient care and documentation in the patient's medical record is delegated to doctors, nurses, and other healthcare professionals. The MRO or person in charge of the medical record department is delegated responsibility for the functions of that department and overall management of the medical record service. Disease classification and clinical coding. Medical records are coded to enable the retrieval of information on diseases and injuries. Used to collect statistics on the types and incidence of diseases and injuries. This information is used for planning healthcare facilities, for determining the number of healthcare personnel required, and for educating the population on health risks within their country. It is used at an international level to compare health status of countries in a region or globally. At present, the International Statistical Classification of Diseases and Related Health Problems, 10th revision, ICD-10, or an adaptation, is used in many countries to code diseases, injuries, and external causes of injuries. ASCII. Alt. The main condition as defined by WHO, 1993, is the condition or the main diagnosis primarily responsible for the patient's need for treatment or admission. If there is more than one such condition, the one held most responsible for the greatest use of resources should be selected. If no diagnosis was made, the main symptom, abnormal finding, or problem should be selected as the main condition. Security. There should be procedures to protect medical records from fire, water damage, pest damage, and unauthorized access. The file room should have a lock on all doors. Access should be restricted to the medical record clerk/officers and to clinical staff out of hours. There should be one open entrance to the medical record file room and a fire exit. There should be a strict no smoking policy in the file room. There should be fire equipment and written procedures on what to do in case of fire in the file room. There should be regular pest control in the file room. Health statistics. At hospital/healthcare facility level, statistics collected from medical records are used to review the incidence and type of diseases treated and procedures performed. Also at hospital level, statistics derived from the daily bed census and medical records are used to assess the utilization of services and enable the hospital to make appropriate financial and administrative plans, and to conduct vital research. At the government level, the Department of Health use health statistics for planning healthcare services and for allocating resources where they are needed most. On an international level, the World Health Organization, WHO, requires healthcare statistics from member nations in order to obtain a picture of the incidence of specific diseases within a region and globally. Meaningful comparisons can be made and differences explained only if definitions of items compared and counted are identical. Who owns the medical record? Medical records are considered the property of the hospital and are compiled and kept primarily for the benefit of the patient. The personal data contained in the medical record is considered a confidential communication and the property of the patient. That is, the information contained in a medical record belongs to the patient and is a confidential communication between the doctor or other health professional and the patient. Although the physical medical record is considered to be the property of the hospital and the information in the medical record is the property of the patient, information cannot be released without the consent of the patient. Exceptions to this rule include the use of the information by doctors and other health professionals for the continuing care of the patient. For medical research where the patient is not identified. For the collection of healthcare statistics when the individual patient is not identified. The medical record is a confidential document and the patient's right to privacy must be considered at all times. Release of patient information. There are 4 methods of releasing information. Direct access to the medical record. Supply of an abstract giving details requested. Verbal release. Photocopying. The department should have specific policies governing each type of release. No unauthorized person can take any or part of a medical record out of file, or read, copy, or otherwise tamper with it. If a request is made for the release of information, the request should contain the following: full name of patient, address and date of birth. Name of person/persons or institution requesting information. Purpose and need of the information. Extent and nature of information to be released, including dates. A recently dated authorization, signed by the patient or authorized representative, example parent of a child. In general, it is best to have written policies relating to the release of patient information, and all staff must be familiar with these policies. General medico-legal principles. As a general rule, no information concerning a patient should be released to another person without the written consent of the patient or the patient's legal guardian. If a patient is under the age of 18 years or otherwise subject to a guardianship order, any consent for access to information should be given in writing by the patient's parents or legal guardian. In the case of a patient who has died, the written consent to access information from the patient's medical record should be provided by the next of kin shown on the medical records or by the administrator of the patient's estate. If the patient lacks the capacity to provide genuine consent, then the written consent must be obtained from the person's legal guardian. Instances in which medical records are used as legal evidence. Medical records are generally used in court for the following: insurance cases, used by the patient for proof of injury and/or disability in personal accident cases or by the insurance company to disclaim responsibility. Workers' compensation. In most countries, a person injured in the course of his or her duties and while acting in the scope of his or her employment is entitled to compensation for bodily injury and disability. The medical record is used as evidence to show the date of injury, the type and severity of injury, and the patient's expected recovery. Instances in which medical records are used as legal evidence. Medical records are generally used in court for the following: personal injury claims. A person may claim to have been injured through the fault or neglect of another and sues to recover damages for injuries sustained. The medical record would be used to show how the injury happened as recorded in the patient's words on admission to the hospital. The medical record would also be used to show the extent of the injuries, treatment given, duration of care and expected recovery or disability. Medical records are used more frequently in this type of case than in all other cases combined. No information may be released without the patient's consent, including the fact that the person is a patient. Where a patient requests that no information be released at all, or information be released in limited circumstances, his or her wishes must be respected. Outpatient medical records. Types. The decision on the type of medical record to use for general outpatients should be determined by the number of daily outpatient attendances, the number of staff available to file and retrieve outpatient records, advice from doctors about their need for previous information on general outpatient visits. Patient-held health record. Consist of the maternal/baby health record. Reduces the huge daily filing problem for general outpatient records. Problems associated with using patient-held health records, however, often outweigh their usefulness. Some of these problems include: the patient does not bring the health record to the outpatients. The health record has been lost. The health record has been tampered with. The data collected in an outpatient medical record should include patient identification as for inpatients, family health history, relevant history of presenting illness and physical findings, clinical observations, reports of tests and procedures performed, the outcome of the visit. For example, follow-up for further treatment, admission to hospital, no further treatment, etc. Growth chart for children. Referral information such as correspondence from a local doctor or community nurse. The doctor/nurse seeing the patient should sign the medical record. Information systems. Many countries now have a number of computerized applications as part of a health information system, HIS, within the healthcare facility. The aim of healthcare authorities around the world is for the development of an automated patient information service that will increase the efficient retrieval of information for patient care, statistics, research, and teaching. Health information systems are designed to integrate data collection, processing, reporting, and the use of information necessary for improving the effectiveness and efficiency of the health service through better management at all levels of healthcare. WHO, 2000. Electronic health records. A health record that reflects the entire health history of an individual across his or her lifetime, including data from multiple providers in a range of contexts. Ideally, an electronic health record should be able to collect clinical, administrative, and financial data at the point of care. Exchange data more easily between health professionals to facilitate continuing care. Measure clinical improvement and health outcomes, compare the outcomes against benchmarks and facilitate research and clinical trials. Provide valuable statistical data in a timely and efficient manner to public health and government ministries. Such reporting of health data is important in the detection and monitoring of disease outbreaks, as well as providing meaningful and accurate statistics to measure the health status of the population. Support management in administrative and financial reporting and other processes. Privacy guidelines for the implementation of the Philippine Health Information Exchange. Department of Health, DO, Department of Science and Technology, DOST, Philippine Health Insurance Corporation, PhilHealth, Health Privacy Code implementing the Joint Administrative Order No. 2016-0002. Rule 1, Collection and Processing of Health Information. Consent, persons to give consent. Consent shall be given by a patient of legal age and sound mind, or otherwise incapacitated to give consent. Any of the following in the order stated hereunder can give consent. A. Immediate relatives within the third degree of consanguinity based on hierarchy, provided that in the case of minors, either parent may give consent, unless the married, in which case, preference shall be given to the mother. B. Cohabitant partner for a minimum of 1 year or actual and identified guardian of the patient. C. Social worker. D. Attending physician. Provided that if a patient has a duly executed advance directive or power of attorney for health care, the same shall be given effect. Valid formats of consent. Consent can either be in written, recorded, and/or in electronic form. It must be signed by the patient, guardian, or authorized representative, in accordance with this code. If a patient is incapable of affixing his or her signature, a fingerprint, thumb mark, electronic signature, or other biometrics may be considered, provided that a witness of legal age and sound mind is present. Revocation and reinstating consent. Where consent was previously given by an authorized representative on behalf of an unconscious or otherwise incapacitated patient, such consent may be subsequently revoked by the latter once he or she recovers consciousness or regains the capacity to give consent. Exemptions for consent. A. For purpose of medical treatment, carried out by a medical practitioner or a medical treatment institution. B. When necessary to protect the life and health of the patient or another person, and the patient is not legally or physically able to express his or her consent prior to the processing. C. When processing is required by existing law and regulation, such as, but not limited to: 1. Act 3573, Law of Reporting of Communicable Diseases. 2. Administrative Order No. 2008-0009, adopting the 2008 revised list of notifiable diseases, syndromes, health-related events, and conditions. Patient Identifier. A patient's unique identifier shall be his or her PhilHealth Personal Identification Number. Highly communicable disease and special conditions. For patients with special conditions and/or highly communicable diseases such as, but not limited to, HIV, Ebola, MERS-CoV, special codes shall be given. Additional documents shall also be signed by the patient, attending physician, and head of the facility. Filing and storage. A. All information collected at different levels of care shall be integrated into a common file. An electronic archiving system shall be developed for the storage of electronic data. B. Healthcare providers shifting to electronic records shall ensure that their paper records are stored properly. Paper records shall be digitized for the purpose of preservation and not destruction. C. Subject to existing regulations, all medical records, whether in electronic and/or paper format, shall be stored for 15 years. For medico-legal cases, records shall be stored for a lifetime. D. Providers of electronic medical records shall have a filing and storage protocol. Rule 2, Access of Health Information. Access of healthcare providers. A. History of past illness. B. Family history of illness. C. History of present illness. D. Clinical history, including immunization records, previous operations, and treatment. E. Allergies. F. Medication history including adverse effects, if any. G. Results of laboratory and diagnostic procedures. H. Treatment outcome, final diagnoses shall be included whether clinical or confirmed. Access of third party. Any third party will be allowed access to health information of a patient in cases required by law, or when such access is authorized under a valid contract to which the patient is a party. Rule 3, Use and disclosure of health information. Use and disclosure. Use and disclosure of health information shall be limited to that covered by the consent given by the patient, or his or her authorized representative, and shall only be for the following purposes. A. Planning of quality services. B. Reporting of communicable, infectious, and other notifiable diseases, including those that pose a serious health and safety threat to the public, such as, but not limited to: A. Meningitis. B. Food poisoning, mass. C. Breakthrough epidemic of contagious disease. D. Biological or chemical warfare. E. Emerging and re-emerging diseases. C. Continuing care to patients. D. Reporting of physical injury. E. Reporting of interpersonal violence to proper authorities. F. Reporting of diseases as registered in the Philippine Integrated Diseases Surveillance and Response. G. Mandatory reporting required by licensing and accreditation bodies, example Department of Health, Philippine Health Insurance Corporation, Department of Interior and Local Government, Department of Social Welfare and Development, etc. Rule 4, Organizational Security Measures. Each health facility shall create its own privacy protocol. Privacy and security policies must be documented, maintained, and updated as appropriate. Authorization and document retention. For identification and authorization purposes, the authorizing entity shall provide any of the following: A. Biometrics. B. Specimen signature. C. E-signature. Rule 5, Physical security. Devices registered with the health facility shall not be brought outside its premises, unless the point of patient encounter is outside the health facility. Such as but not limited to the following scenarios: vaccinations, remote visits, and other similar or related community-oriented activities undertaken outside the health facility. Where devices are brought outside, proper documentation and security checks must be carried out. As a required minimum, the following security measures should be in place: A. Hard disk encryption. B. Data encryption. C. Wireless network. D. Role-based access control. E. Antivirus software for vulnerable operating systems. F. Password-protected user access that complies with facility password policies of the health facilities. G. Encrypted portable devices such as, but not limited to, flash drives, secure digital, SD, card drives, rewritable compact discs, CDs, and other present and future devices. Business continuity and disaster recovery. The health facility shall implement policies for business continuity and disaster recovery. Physical backup. Business continuity. Rule 6, Technical safeguards. Access controls. Information access management, required. User identification, required. Emergency access procedure, required. Automatic log-off, addressable. Encryption and decryption, addressable. Multi-factor authentication, addressable. Audit controls. Recording of information, required. Audit data lifespan, addressable. Access to audit data, addressable. Integrity controls. Mechanism to authenticate electronic health information, addressable. Digital signatures, required. Some verification, required. Antivirus software, required. Data storage encryption, required. Transmission encryption, required. Proper handling of mechanical components, addressable. Offline modes and caching, addressable. Interface integration of information systems, addressable. Transmission security. Identity authentication. Storage security. Rule 7, Cloud services. For cloud service providers, there shall be in place appropriate audit mechanisms and tools capable of determining how data is stored, protected, and used, and of validating services and policy enforcement. A risk management program that is flexible enough to deal with the continuously evolving and shifting risk landscape. Adequate and secure network communications infrastructure. There should be a contract between the health facility and cloud service provider. Rule 8, Use of social media. This refers to electronic communication, websites, or applications through which users connect, interact or share information or other content with other individuals, collectively form part of an online community. This includes such online platforms as Facebook, Twitter, Google+, Instagram, LinkedIn, Pinterest, blogs, social networking sites. Unauthorized posting of personal data of patients in social media, including pictures, shall be penalized in accordance with the provisions of the DPA. Health facilities shall provide for guidelines regarding the use of social media. In line with this, the social media activity of all facility personnel, whether temporary or permanent, shall be monitored for any privacy breaches. For this purpose, facility personnel shall include a. Physicians, b. Employees, c. Other healthcare providers, d. Students, e. And residents in training, practicing their profession, working, or fulfilling academic and clinical requirements within the health facility. Unprofessional behavior or misinformation witnessed in social media that violates patient privacy or privacy of other individuals shall be reported to appropriate authorities. Healthcare professionals shall always be mindful of their duties to their patients, community, their profession, and their colleagues. Thus they must take into account that any content, once posted online, may be easily disseminated to others and is essentially irreversible. Caution must be observed when sharing health-related information, education, and promotion for advocacy purposes. Only general opinions may be shared in social media. Specific medical diagnosis, advice, treatment, or projection shall not be dispensed with therein. Accordingly, social media use, whenever appropriate, shall always include statements reminding the public that they should not rely on advice given online, and that medical concerns are best addressed in the appropriate settings. For social media use to crowdsource support, identity of the patient can only be revealed to the support group upon patient's consent. Confidentiality of data shall still be upheld by removing any information or features that are easily identifiable to the patient. A healthcare professional shall strive to develop, support and maintain a privacy culture in the health facility. He or she shall abide by the social media use policy of the facility. Advise the patients of their privacy rights and encourage them not to post in a social media any activity or confidential information that may put them at risk, such as, but not limited to medical diagnosis and laboratory results. Conduct himself or herself in social media or online the same way that he or she would in person. For this purpose, he or she shall act in a manner befitting his or her profession, thereby inspiring trust in the service he or she provides. This is particularly the case if said professional maintains the same social media account for both his professional and personal lives. Refrain from using the name, log, or any other symbol of the health facility in his or her social media activity, without proper authorization. An individual shall also not identify himself or herself in social media as a representative of the facility absent any authority to do so. Refrain from posting, sharing, or using photos or videos taken within the facility that will violate their right to privacy. Rule 9. Human Resources. Security roles and responsibilities. An individual shall a. Implement and comply with the health facility's information security policies. b. Protect assets from unauthorized access, disclosure, modification, destruction, or interference. c. Execute security processes of specific activities. d. Ensure responsibility is assigned to an individual for actions taken. e. Report security events or potential events or other security risks to the organization. Background verification checks on all candidates for employment, contractors, and third parties shall be carried out in accordance with relevant laws, regulations and ethics, and shall be proportional to the business requirements, the classification of the information to be accessed, and the perceived risks. Procedures shall define criteria and limitations, e.g., who is eligible to conduct screening, manner by which screening shall be carried out, etc., for verification checks. Disciplinary process. There shall be a formal disciplinary process for personnel charged with having committed a personal data breach or security incident, or, by the negligence, allowed such breach or incident to occur. Rule 10. Health research. Research subject. Research participant shall be made to understand that he or she can opt out of the study or have his or her personal data deleted from the project's database if they relay such request in writing. A. Acceptable recruitment methods. Acceptable methods for recruiting research subjects may include advertisements, notices, media, social or tri-media, websites, letter or email to colleagues or healthcare staff that may be distributed to potentially eligible individuals. B. Unacceptable recruitment methods. Unacceptable recruitment methods for recruiting research subjects include 1. Searching through medical records or databases, e.g. patient registry, for qualified subjects and having a researcher with no prior contact with potential subject recruit. 2. Recruiting subjects immediately prior to sensitive or invasive procedure, e.g. in pre-op room. 3. Retaining sensitive personal information obtained during screening without the consent of those who either failed to qualify or refused to participate in any possible future study. Research projects. A research project involving 1,000 or more data subjects shall register with the National Privacy Commission and/or its duly deputized body, for health research, possibly the Health Privacy Board. Rule 11 Patient Registries. Registry design. Any give registry shall be developed with a clearly defined purpose, i.e., disease condition, health service registry, disease outcome, etc., to avoid both ethical and compliance issues that may undermine the attainment of such purpose. Registries compiling health information from vulnerable populations such as but not limited to pregnant women, human fetuses, neonates, prisoners, children, and patient having rare diseases shall employ special effort to protect identities of these subjects. Rule 12 Publication and Public Communication. Publication of privacy policy. Privacy protocols of health facilities shall be available both in written and electronic forms and shall be distributed to all employees. Health facilities shall ensure that appropriate signage indicating the availability of protocols are posted. Privacy protocols of health facilities shall be updated and submitted to the Health Privacy Board and insofar as practicable, be made available online in its own website. Site privacy policy. A. For facilities maintaining public-facing websites. A. Any information that may compromise the privacy of the patient shall not be posted in the website. B. Any data collected by the website shall be treated with utmost confidentiality. C. Where applicable, the health facility operating the website shall declare that it uses cookies to manage authentication, navigation, and other functions. It shall also actively request a site user to agree that these types of cookies can be placed on one's device. Rule 13, Health Privacy Board. The Health Privacy Board is a broad sectoral response to health information privacy needs. It will support the health sector in complying with issuance and administrative orders relating to health information privacy and further the development of policy and practice for health data protection. The Health Privacy Board shall be composed of the chairperson who shall be assisted by 2 board members, responsible for training and capacity building and responsible for compliance and planning. Rule 14, the privacy team of a health facility. The Data Protection Officer, DPO, shall be designated at a health facility. The DPO's identity shall be made known to any data subject upon request. It is recommended that the DPO has to be on the vice president level, or equivalent, to have sufficient authority to uphold privacy in the institution. Expected to have some personnel with specialized privacy roles are regional health units, RUS, and bigger health facilities. In a facility where a position for a data protection officer could not be immediately secured, a privacy officer designate shall be appointed. Hospitals with at least 300 authorized bed capacity shall employ a full-time data protection officer. Hospitals with less than 300 authorized bed capacity and other health facilities such as infirmaries, birthing homes, RUS/BHS, OFW clinics, dialysis clinics, ambulatory surgical clinic, psychiatric facilities, etc. may federate and designate a shared data protection officer. The Development Management Officer, DMO, shall be assigned as the Data Protection Officer designate for rural health units. This shall be in addition to their responsibilities as DMD. Rule 15 Compliance, Incident Reporting, Response. Health facilities involved in the PHIE are required to A. Register their data processing systems involved in the PHIE process to the Health Privacy Board, including the data processing system of contractors, employees, and third parties entering into contracts with them that involves accessing or requiring sensitive personal health information from 1,000 or more individuals. B. Notify the Health Privacy Board of automatic processing operations being carried out by the health facility, its contractors, and third parties. C. Submit a copy of their privacy policy as well as the list of personnel having direct access to health information to the Health Privacy Board. D. Submit an annual report on documented security incidents to the Health Privacy Board. E. comply with other requirements that may be provided on their issuance issued by the National Privacy Commission or the Health Privacy Board. Rule 16 Procedures in the investigation of complaints filed before the Health Privacy Board. A complaint shall be in writing and under oath or embodied in an affidavit. The complaint may be filed by any person, firm, partnership, association, or corporation, through its duly authorized representative. The complaint must be written in a clear, simple, and concise language and shall contain the following. 1. Full names and complete addresses of the complainant and the respondent. 2. A brief narration of the material facts which show a violation of the privacy guidelines or related issuance, or the acts or omissions allegedly committed by the respondent amounting to a privacy concern. 3. If the complainant contains personal and sensitive information involving third parties, which information will be disclosed to the Beard, the complainant shall include proof that consent of said parties have been obtained with regard to the use, access, and disclosure of said personal or sensitive information for purposes of resolving or adjudicating the complaint, before appropriate bodies. 4. If the complainant is an institution, the complaint shall be accompanied by the incident report or relevant document showing the results of the investigation conducted within the institution. A complaint may be filed at the office of the Health Privacy Board. Rule 17, Penalty Clause. Any participating healthcare provider or patient who shall fail to comply with the provisions of this order or who shall commit any acts that violate the Electronic Commerce Act of 2000, Cybercrime Prevention Act of 2012, and the Data Privacy Act of 2012, shall be penalized with termination of the right to participate in the PHIE, and revocation of all privileges enjoyed pursuant to said participation. Authorization to access the PHIE revoked, in addition to the disciplinary actions imposable under rules of the concerned agency, institution, company, or organization. Thanks.